Good afternoon, and welcome to the Baylor Law Executive LLM and Litigation Management's monthly roundtable. We've got a doozy for you today. We've got some of the top minds in the field talking about the very hot issue of litigation funding. Should it be discoverable? And if so, what are the parameters of that? And as always, we've tried to gather different viewpoints. And so I will start by introducing Justin Mallison, who's with Longford Capital and is in the litigation funding field. Mark Behrens, a partner at Shook Hardy Bacon, who has written fairly extensively on the issue. And then finally, but certainly not least, Professor Maya Steinitz, who has both written on the subject and served as an expert witness where this has been an issue. So welcome to all of you. We're really glad to have you here today to hear your thoughts on this topic. I'm going to start with this question of litigation funding in 2022. Does what we see today look like what litigation funding was like a couple of years ago? And Maya, let me kick this one off to you to hear your thoughts before our other panelists chime in.
Thank you, and thanks for inviting me. I'm very honored to be here amongst these panelists. Litigation funding is a relatively new industry. And as such, it's evolving very rapidly. The two, three largest changes I would note that happened in recent years are as follows. One is we're seeing a move from funding of individual cases to funding of portfolios of cases. And these are arrangements that have different economics, different ethics, they're very different. Another thing we're seeing is a rise in the funding of mass and class actions in litigation and in arbitration. Again, just like class and mass actions have all kinds of different unique procedures, it's true on the funding front. And then the third thing I'll say that's the most breathtaking development is that in January 21, Arizona became the first state to allow non-lawyers to own and manage law firms in Arizona, as long as they adhere to a very complicated regulatory regime. And other states are looking into these kinds of developments, Utah, California, and others. So these, I would say, are the biggest changes in the last 2-3 years.
And of course, the irony is funders and people saying we will die on the hill of never funding class action or mass torts, and now it's becoming the norm. Justin, you're on the capital side. How is the funding landscape looking from your perspective now?
I think the professor is right. I mean, it's certainly developing, and I think as an industry, while the asset class has been around now 10-15 years in this country, I do think there's still a lot of room for growth and development. There has been a shift. There's been a lot more portfolio funding, both on the law firm side and the claim owner side. So it's not limited to law firms in the portfolio setting. And I do think, kind of given the influx of capital and influx of funders that have, it's grown obviously in recent years, there's more creativity and there's different types of funding products that are coming out there. And I expect there to be continued development as we go forward. But yeah, the industry is growing, the industry is changing. I think like any industry at this stage, there's sort of a lot of innovation and a lot of growth, and we'll continue to see it.
Justin, I think your point is a good one when you say in this country, because non-lawyer ownership of firms and litigation funding have been in use far longer in countries around the world, the UK, Australia. How much are you looking to that experience for guidance?
Well, I mean, my full disclosure, and my experience is limited to kind of what I see, and it's hard for me, and I'm not able to comment on how other funders are sort of approaching it. We have an eye on, and we're familiar with sort of the history and how things have developed in other countries, but we're more focused, frankly, on what's happening here. whether or not kind of the life cycle in those countries is impacting what's happening here, I'm not sure. But I think here, the case law, the body of case law has been continuing to develop. I think funding's become a lot more mainstream and more generally accepted. And so I think that's really what I've been seeing, what I've been focusing on.
Mark, I want to turn to you because I know this is a topic on which you've written a good bit, and that is the issue of disclosure of whether there's litigation funding, disclosure of the terms, parameters, and fair warning. I'm circling around to everybody on this one, but kick off our discussion. Disclosure, yes, disclosure, no, or a great lawyer answer in between.
Disclosure, yes. I think from the perspective of so our firm represents defendants in complex cases, many mass tort cases. And I think among our mass tort defendants, and I also do work in this space for the U.S. Chamber of Commerce Institute for Legal Reform, which has a broad-based membership. And I think both the Chamber's perspective and our mass tort clients, are very strongly in favor of disclosure. And, for reasons that we can get into. I also wanted to make a point on some of your last discussion in terms of where is this headed in general, litigation funding in general. I agree with all the points that have been made that we're seeing more portfolio funding. I think that's probably a function of more money pouring into this space. When you have a small amount of money, you invest it in one case. When you have billions of dollars flowing into the space, you can't afford it on that scale to pick individual cases. So I think the portfolio funding is a reflection of the amount of money that is pouring in and the growth of the industry. And I think we're going to continue to see this, particularly with the economy struggling. When you look at inflation and you look at the economy, seemingly melting down in the last 6 weeks or so, and it's going to continue for probably through this year, I think that more people will look to litigation funding because we saw 10 years ago when litigation funding really first took off in the United States, that just so happened to be occurring at about the time of our last financial crisis. And I think one of the things that makes litigation funding attractive to capital investors is that it's not tied to the underlying conditions of the economy. So the economy, the housing market, because of higher interest rates and the stock market crash, could cause people to stop buying houses, buying new cars, buying road building equipment, things like that. But litigation is going to chug along, and so I think we're going to look. There may be more money and more people looking to this space for a place to put their capital over the next couple of years because of where the economy is going.
Well, and Mark, I think that's a great point because, and Justin, I know this is something Longford routinely does. It also lets the investor, the provider of equity, do their own independent analysis and due diligence and ensure their confidence in the investment in a way that is somewhat more secure than others. But I want to get back to your position on disclosure. Disclosure good. Give us your top couple of reasons. And if you wouldn't mind, expand a little bit, just disclosure of the presence of funding or more.
Yeah, I think, if you ask, again, most of the mass tort clients and chamber members, they would probably say we would prefer a world with no litigation funding. But that horse is out of the barn. So I think disclosure is sort of the next best approach that they've looked at. And I think what is driving that is to know who the real party in interest is in the case, and to know who's driving the litigation and who ultimately has authority to make litigation decisions and settlement. Because the one thing that companies don't want is to talk to plaintiff's counsel and believe that there's a deal, only to find out that when there's agreement, the person has to say, well, hold on, I've got to go make a phone call. There's actually somebody with an interest in this case that hasn't been in this room working things out. And I need to talk to them before we sign on the dotted line and close this deal. And I think it's that complexity that's added to this litigation when there's a funder involved that is one of the reasons why businesses are in favor of disclosure. Another is to make sure that in states that still have laws against champerty and barratry, that there are no ethical problems going ahead, and that there are no conflicts between the judge and the funder. But predominantly, it's about making sure that the real parties in interest are the plaintiff and plaintiff's counsel and not the funder, and to make sure that the people that are involved in settlement actually have authority to settle the case.
Maya, I know you've done a lot of research on these contours and issues. Weigh in a little bit on some of Mark's concerns, your views on disclosure parameters from because I think you've been both an expert and then you've written a very compelling law review article on this, which, by the way, viewers, the professor has agreed we can make available to you.
Absolutely. Thank you so much. Disclosure was, I'll maybe back up into an answer by saying something about this paper, which is called Follow the Money ? And has a subtitle, is I would be asked for, over the course of 2-3 years, journalists would ask me whether I'm in favor or opposed to disclosure, and it would always come up in a different context: international arbitration, Peter Thiel funding, the case against Gawker, and depending on the set of circumstances that they brought up, I sort of gravitated in a different direction. And so ultimately, where I ended up in what I propose in the paper is that there should be a balancing test. I don't think that when you look at all of the variables in litigation, I don't think we can have a bright line rule, always disclose or never disclose. And I don't think we can have a bright line rule of here's what you should disclose, because one question is any disclosure, yes or no, but the other is how much. Just the fact that there's a funder, the identity of the funder for conflict purposes, the funding terms, the funding amount, right? These are actually separate issues. And so when you start looking at the variability of the subject matter, the parties, the forum, the stage of the litigation, I believe you see that it's very hard to come up with a one size fits all. So I propose a balancing test in the paper. I kind of suggest the private interests, the public interests that should be balanced by judges. And here I'll weigh in, and since you asked about what Mark says, I think that defendants have in certain contexts legitimate concerns about, yes, wanting to know whether there's a conflict of interest. And by the way, that's a much more acute issue in international arbitration, domestic arbitration, even than in courts, or who's the real party in interest. On the other hand, there was a hint, I think, in what Mark has said, he'll correct me if that's unfair, what I'm about to say, but that part of the reason the disclosure has been sort of a cause célèbre for the Chamber of Commerce and others is because it's the closest thing to sort of regulating litigation funding out of existence. And I personally think that's not desirable. I think litigation funding is a desirable option to provide to clients. And so where I think funding becomes possibly inappropriate is where there's strategic considerations that are not the merits. If the idea is how much funding, how much money is available to the plaintiff, and how can I spend the plaintiff out to the point where I exhaust the resources, personally, I don't think that that's a reason we would want disclosure ordered.
Justin, you're on the equity side. What are your views on this?
Yeah, I have a few thoughts on this. So in terms of, and this may be surprising, I'm not anti-disclosure at all. I think disclosure, frankly, is beneficial. I just think there should be reasonable limits on disclosure. I'll just say one of the reasons that I'm not against it is I think it's a signal, right? When you have an independent entity, right? My job is to make money for investors, right? That is what our business is. We're highly selective in the cases we invest in. We do a lot of due diligence before we invest in them. And so the fact that, we've gone through our process and have elected to put money behind the case is frankly a signal, and should be a signal that, several different lawyers have looked at this, evaluated this, and there's merit to the claim. So I'm not anti-disclosure in any way. Where I think the push for disclosure goes too far is when it gets beyond, it becomes a fishing expedition. So to Mark's point, well, I think in every industry there's going to be a few bad eggs. I think by and large, this, the industry, right? Most funders are reputable and they're not making decisions. We're certainly not controlling or making decisions. We are explicitly not making decisions. Besides being ethically prohibited, no lawyer wants another lawyer looking over their over their shoulder, right? And so from a business development standpoint, to kind of zero back in, it would be pretty hard for me to get more clients if I'm sort of second guessing and dictating what lawyers could do. I mean, I was a practicing lawyer for a decade before I did this. And so the issues of real party and interest and who has decisions, who's making settlement decisions, who's making litigation decisions, by and large, I don't think that's a concern. But those are the kind of things where in the opioid litigation, for example, the court issued a standing order that said, if you have funding, submit to me in chambers, affidavit from lawyer and funder, say you have funding, tell me who the funder is, confirm there's no control, confirm the funder has no authority. And if there's other good cause, come to me. But otherwise, it limits the scope of disclosure while addressing the issues that Mark's raised. So that's a lot, but I'm generally pro disclosure, but it's a client call. It's not my call. If the client sees value in it, it's the client's call, the lawyer's call. But in general, I just think there should be limits on it.
Mark, if you have that kind of disclosure, okay, you've got to tell me who the funder is. Everybody's got to pony up under penalty of my raining on your parade in a really hard way with hail and lightning, and whether there's control, et cetera, and everybody attests to that. Does that, vetted by the judge, does that assuage the concerns that you see?
It goes a long way. And I wanted to address Maya's point, because I think also when we talk about litigation funding, whenever I've given talks on this in their group, I'm always very careful to kind of define what we're talking about in that space, because sometimes people talk about litigation funding in referring to loans to consumers. So, there are companies out there that make loans to consumers that have litigation pending. And it's sort of like, I will help you make your house payment, your car payment. And then when this case settles, I'm going to get a percentage of your win. I'm going to get my money back plus some percentage. And I think there have been more steps towards regulation, because you're dealing with consumers that are not necessarily sophisticated purchasers. And so states in that area have looked to regulate more like they would in any other loan context. What the chamber's been involved in, and I've been involved in with them and other groups, has been more on the loaning to law firm model that I think we're focusing on today. And the point there, to my experience, has not been to regulate the industry out of existence at all, but simply to require disclosure of the agreement. And I can understand where there may be competitive reasons why the industry, a particular company, wouldn't want the terms. This is how much we're making on this to be public. But the reason why I think there's an interest in the disclosure is to get to that issue of who is really calling the shots in this lawsuit. Because I've always felt that if all the litigation agreement says is, we agree to give you money and you will run the litigation, you will decide who the experts are, you will decide when the case settles and for what amount. And when you make that decision, lawyer, then we're going to get our money back plus some return on investment. I think if that's what the agreement actually says, then no funder should ever have a problem producing that. In fact, you would think plaintiff's counsel would want to announce that they have this. I actually think there may be a day when plaintiff's counsel will be the ones making that disclosure, because they will want the defendant to know that they are funded, that they're not going to run out of money, somewhere along the course of the litigation, that this isn't David versus Goliath, this is Goliath versus Goliath, and they've got the funds to run this litigation and prosecute it as well as any large company would. And so, I don't know why disclosure is problematic unless the agreements, in fact, do suggest that the funder has some say in how the litigation is managed.
Well, Mark, let me tease that apart, because this started with really the concerns get assuaged if we know that there is funding, who the funder is, and there's an attestation or affidavit or something from the funder and the firm or whoever the recipient of the equity is, that there is no provision of control. Then what I heard you say, and I certainly could have misheard, was no, we need the whole agreement. Is that your thought, that it's not enough to have everybody attest, but the defendant needs the ability to double check their veracity by seeing the agreement itself?
Yes, that's been the position so far in the legislation that's been advocated around the country and that passed in Wisconsin.
Thoughts on that, Maya?
Yeah. So again, I think it's circumstantial, and there could be circumstances where that would be appropriate. But I think that there's circumstances where it's hard to think why a defendant needs to see the financial terms, for example. So I'll give you an analogy. If I have no money, I have a meritorious claim, but no money, and my mother-in-law offers to fund my litigation, in reciprocity for that, she's requiring me to show up for dinner every Friday. Is this anybody's business? I think not. I think that's just my private financial matters. And so where I start the analysis is I start with the idea that finances are private. Now, sometimes there are considerations to trump that, but that's where I start the analysis. And again, I think there's a real concern with the financial terms being used to just figure out, how much motions and discovery and so forth should I seek to just exhaust the available funding. And as Mark acknowledged, some of this is proprietary. So I think it's all context specific.
Justin, on the equity side, what do you think? And then Mark, it looked like you had a thought, and I'll get right back to you.
No, I mean, I think, I guess to respectfully disagree with Mark. I think the idea of, having both parties attest and then giving to the court in camera and having a judge say, okay, there's no control, I'm comfortable, but then the defendant wanting to double check, that to me is a bridge too far. I think that goes, kind of beyond the bounds. And I would say Mark, you'd raised the point of, if there's no control, sort of what's the concern? Why not just hand it over? And I think there's information to be gleaned in funding agreements that have nothing to do with control that, for example, go to how the plaintiff assesses the case financially, or kind of where the pressure points are, depending on how the budget is set out, how much money is made available, as Liz mentioned. It's, where can we push to exhaust it? And I think that information has no bearing on the claims or defenses. And that's what courts have consistently said in denying disclosure on relevance grounds. And so I certainly understand, I was a defense lawyer for most of my career before I started doing this. I certainly understand the desire and the interest in having the information, but in terms of a relevance perspective and in terms of, what it provides, to me, it's a bridge too far. And I think it's sort of an unfair imposition that doesn't actually go to the merits of the case.
Mark, I didn't have a thought.
Yeah, thank you, Justin. The point that I was going to make too is that one of the things that that civil justice reform groups have heard when they've advocated for disclosure, whether it's in state legislatures or before the federal judiciary, lawyers for civil justice and the U.S. Chamber have made a number of submissions to the judiciary saying there should be, incorporate initial disclosures into the federal rules, like you have to disclose insurance agreements. And one of the things that we often hear from the judges is we don't know that there's a problem out there to regulate yet, because there's no information about how often is this occurring. Is this in 5% of mass tort suits, 50%, 80%? How prevalent is the industry? really nobody knows. But maybe some of the funders that are involved do, but the judges will ask questions. How do we know that this is a problem that needs to be addressed? And it's a catch-22 for our side, because we say, well, we have no information because it's all done in secret. That's the whole point. That's why we need disclosure, to bring this out so we can get some data on how prevalent the industry is and what effect it is having on litigation. Does it prolong cases like we believe? Does it make them more difficult to settle like we believe? Does it run up the cost of settlements like we believe? But there's no hard data out there because this is all operating sort of in the shadows. And that's where I think from the business perspective, disclosure would help inform the public and the judiciary about, the impact that this practice is starting to have in our civil dockets.
That's really interesting. I guess a couple points to kind of counter that. One is in terms of the insurance analogy. So the difference, I think, between this and the insurance being required is insurance coverage is typically purchased before the occurrence of a claim, right? Before the claim is actually triggered. And so a funding arrangement is after a claim has occurred. And so in that situation, the points I was mentioning a moment ago in terms of reflecting sort of case valuation and where the pressure points are, it's a different tension. And so I don't think it really applies, apples to apples in terms of the insurance and funding. The other piece is, I would say, again, I'm not against disclosure. I think there's benefits to funders that be, having disclosure out there. I think though, in terms of looking at it as an industry, I think regardless of how prevalent it is as an industry, it has no bearing on a single case, right? That's why we have certain rules to prevent things exterior to the case from coming in, is because every case should be decided, on its own merits, regardless of what else is happening out there. And in terms of your point of making it more difficult to settle prolonged cases, so I don't have an answer to that, but what I can say is I've certainly heard that argument, and I know I've heard some folks articulate the rationale as well. Funders are pulling the strings. Funders are saying no. Again, not what we do at all. But what I see is the countervailing reason why that may be true is, for a long time, defendants have, again, rightly or wrongly, used their financial disparity, the financial might, to sort of exert pressure to resolve cases other than on the merits. And with funding, it allows plaintiffs to sort of balance the scales, where plaintiffs aren't going to be forced to have to take a settlement lower than they feel they deserve because they just don't have the resources to litigate the case. It allows cases to be resolved on the merits, which certainly could have the impact of prolonging cases and limiting settlements, given the defendants' historical sort of, we're used to settling these cases for a couple $1 million. Now the scales are more balanced. Plaintiffs have the ability to fight longer because, one, they have the resources, but two, they now have another set of eyes, right? In our case, we have 2 levels of diligence, us, another firm we bring in. So 3 sets of lawyers have said, wow, we believe in your case. We believe in it so much, we're willing to put our money behind it. And so I believe that plaintiffs are also feeling more comfortable that, yeah, I have been wronged here and justice should be served. So again, I don't know the reasons. Those are just some other points that are important to consider, other than just funders are controlling things, which again, it's certainly not my experience, and not my experience with any reputable funder of the industry.
Maya, weigh in.
Thank you. I want to just contribute a few reactions. One, on the issue of control, I agree that there are different business models in the funding industries. I've observed it. And some funders are passive funders. They vigorously due diligence the case, and once they decide it's a good one, they fund it. And they want to be appraised of important developments, but otherwise they're hands off. The other model is to actively manage the investment, which from an economic perspective is legitimate, right? Just generally vis-a-vis investments. Now, one of the things that I think is important to point out, that control can be tricky to identify. So I've seen contracts where funders explicitly state in some clause that they take no control, but when you analyze the economic of the deal, they do have control. And 2 ways that comes about, predominantly, there's others as well, is 1, stage funding with the ability to exit midstream. So that means I'll give you a first tranche, and there's 3 more but I don't have to provide the others, right? So obviously, if that's your model, de facto, the funder has control. Another is retaining the ability to install and replace lawyers, and those lawyers have repeat play relationships with the funders. So just for sort of the benefit of the audience, I would just mention that detecting control can be a little bit tricky. By the way, I think there are conditions where it's legitimate for, in the commercial context, in the consumer context, to sell control to the funders. So I don't necessarily think it's a problem, but that's on control. And the insurance analogy, I want to say there's a value to it in certain contexts, but the reason that there's mandatory disclosure of insurance is for the benefit of both parties and the system, so that if there's no way to recover at the end of the process, not to put everybody, including courts and jury, through a process where at the end of the day, a winning party is not going to be able to recover. So that's not analogous to what's happening on the plaintiff side. I wanted to, and the data point. I would love to see, as a researcher, more data. The industry is opaque. The data is private. I just would like to see the same principles applied across the finance industry. I'd like generally to know more about the finance industry. Litigation finance is a pocket of the finance industry, and I'd love the Chamber of Commerce to join in an effort to bring more transparency to the finance industry. And I had another comment, but settlement. I'll say this. Economists of law have argued both ways and modeled and provided all kinds of arguments as to whether litigation funding will tend to prolong litigation or actually contract it. You can make the argument both ways. And just on the sort of side of the litigation funding can actually shorten the process. Litigation funders have, under certain circumstances, an incentive to actually cycle through an investment within about 18 months and then use the funding otherwise. So a co-equal concern is that they'll pressure plaintiffs to settle early rather than that they'll prolong the litigation.
We had a question from one of our viewers. It's very interesting. I'd love to know, have you ever seen a funder required to attend mediation? I mean, if this
I have not.
Yeah. Sorry, go ahead, Justin.
No, I have not. I have not seen that.
Mark, have y'all had an issue where you believed a funder was such a real party in interest or had control that you advocated that they be required to attend?
I haven't had that experience, but I'm not litigating in the courtroom. I think, I wanted to go back to a point, though, that Maya had made about some of these agreements give more control to the funder than others. And, if there's any control to the funder, that creates ethical problems for the lawyer, because the lawyer always has a duty to exercise independent judgment. And that's always the rub, whether you're talking about litigation funding or, non-lawyer ownership of law firms and fee splitting with lawyers, fee splitting with non-lawyers, is once you get into that world of the funder having any control over the litigation, you are compromising the lawyer's ability to exercise independent judgment about what's right for the client. Because the client may have an interest. If you have somebody with, let's say mesothelioma and they have 6 months to live, maybe they need the money. But the funder's interest might be, well, we might be able to get more money if we take this case to judgment and obtain a punitive damages award, let's say. So you're going to have a rub there between the lawyer's judgment and the client's. And even when there's no control that's stated in the funding agreement, the business community's concern is that leverage is there, whether it's stated in the agreement or not, because any lawyer that's getting funding probably has to be aware that if they don't play by the rules that the funder is setting, they're probably not going to get funding again in their next case. And so I think that those are concerns that weigh on the lawyer's ability to call the shots in the case, regardless of what the funding agreement itself might say.
But are those same concerns not present in every insurance policy that awards the carrier the contractual right to choose counsel, the contractual right to control the defense, and in the absence of a consent to settle provision, the ability to decide whether the case gets settled or tried. I mean, don't we have a parallel body of law that already protects the interest of, or at least acknowledges, we have states that are the triumvirate, relationship versus others. Don't we already have parameters for those duties and how we protect those?
Well, I think in the insurance industry, if in a particular case, the insurer is not putting the policyholder's interest first, they open themselves up for a bad faith lawsuit. So, there is a very heavy tort incentive on the part of the insurer to put the policyholder's interest first.
May I weigh on that, Liz? Yeah. So first, I want to, again, agree at least partly with Mark. I do think that when control is ceded, usually indirectly to the funder, issues of independent judgment arises. And by the way, even if control isn't ceded, just the fact that there's a repeat play relationship with the funder is something to monitor in terms of independent judgment. That said, I think that when we're dealing with sophisticated commercial clients, we generally allow selling control of all kinds of assets in return for a control premium. I'm not sure it's a problem. The other thing is I want to just point out how this issue highlights the importance of a balancing test because it's so context specific. What do I mean? If we're talking about control and independent judgment in the context of a class action, I think the defendants have a due process, right, to sort of figure out who's controlling and whether the lawyers on the plaintiff side of independent judgment. Conversely, if it's an individual lawsuit, the ethical duties of the lawyers, the plaintiff's lawyers, belong to the plaintiff. We don't generally have in our systems defendants policing and protecting the plaintiffs and their rights vis-a-vis their lawyer. We have an adversarial system. So when an opponent sort of comes in and says, let me help you out with your relationship with your lawyer, I sort of question that a little bit. Another thing I want to say about the limits of the insurance analogy, which is an important analogy. And I agree, Liz, conceptually, that we have a context where we allow a funder, namely an insurer, to take control and subrogate. But there's a limit to the analogy, which is the insurance industry is heavily regulated. There's a duty to fund, for example. So the scenario of the funder just stepping out and saying, I'm done for whatever reason or no reason, we don't really see in the insurance analogy. So we just need to be sort of really granular when we make the analogy.
I ask a question about this, and so it's interesting, Maya, that you said that. So as I understand it, and I'm not educated in the insurance world, but what I've been told is something called a hammer clause in a lot of these contracts, where if a settlement of $20 million hits the table to a defendant, if a defendant doesn't take it, then they lose the coverage. So I guess I would argue that is a situation that seems to go directly to what we're talking to. Again, this isn't an area of my specialty, but that to me does seem to go directly to the point where the insurance company is effectively dictating what the defendant can do, because if they don't take the settlement, they lose the protection.
Insurers can take complete control. Subrogation means stepping in the shoes of the client. And so that's why I think it's important to say we do have a context in our legal system where we allow someone to step into the shoes of the client. And so sort of broad statement that that's always bad is something I would sort of be a little, personally, I kind of try to think through them a little bit more granularly, but the rights of insurers are embedded in an entire regulatory regime that also imposes duties on the insurers. For example, insurers need to be properly capitalized. That's just an example. So, I mean, maybe we want litigation funding to be as heavily regulated as the insurance industry. I'm not sure, but I just want to point out that there's an entire context, and we need to see the rights and obligations of insurers as part of an entire balanced kind of system. Whether it's balanced correctly or not is, for the insurance scholars to debate.
Can I ask one question, and then I don't mean to step on Liz's role here, but at least in the insurance market, you have the consumer is contracting directly with the insurer. So they can work out the terms or whatever. They're agreeing by contract to cede control of a case to the insurer, if you will. So that's the consumer's choice. But I'm not sure in the litigation funding context whether the plaintiff is making that choice to bring in a funder, or whether the plaintiff is even aware that there is a funder.
I can address that.
So the reaction there, because I think that's where there's a difference between the insurance analogy.
So there's two types of, well, there's two counterparties to a funding agreement. It's either the law firm or the claim owner, right? We do the majority of our deals directly with claim owners. It's pretty close to 50-50, right? It shifts. So when we do a claim owner deal, they are the ones that we're contracting directly with. So they're making their agreement with us directly. In the law firm context, we always, without fail, require there to be full disclosure of our involvement with the firm. We never enter into a funding deal where, with a firm involved in a case, where we do not also require them to notify the claim owner as to our involvement. So for us, again, I can't speak to every funder, but with us, it's important that transparency, everyone knows what's happening here.
I want to pitch one last question to you on this issue of, does it make claims more difficult to settle? And full disclosure, a BOTA member, champion of the 7th Amendment right to trial by jury. So I'm from, that. Is it a bad thing that more cases go to trial because of, in the presence of, there's causation and correlation, but is it a bad thing if more cases go to trial? What do y'all think? Ooh, we can play Stump the Panel.
No, I'm happy to go and say that, yes, I have some reservations about sort of the federal policy of encouraging settlements. Sometimes settlements are good and sometimes they're not good. And so I certainly don't think that there's a problem if there's a plaintiff who believe that their case is a case of first impression, or for whatever reason they want a jury to weigh in on that. I certainly don't think that that's a bad thing.
I don't have, it's probably cliche, but I'm a believer that cases should be decided on the merits, right? And not because of who has more money at the end of the day. And so to me, that's one of the things that drew me to funding in the first place, is sort of the access to justice aspect of it. So I don't have a strong feeling either way, other than to say, like, I don't want cases being decided by who's more mighty in the bank.
I think, it really depends on we have to keep in mind that the litigation isn't just a financial transaction. It does involve a real person, in the mass tort context, somebody that's claiming an injury, and it's their lawsuit. Now, it's being facilitated by a lawyer and maybe funded by a funder, but it's the person and their family. And I don't think we can lose sight of that. And you always have to go and say, what is in the best interest of the plaintiff himself or herself? And because in some cases, maybe it is in their interest to take a case to trial, but in many others, it may be our family needs the money now. And, and so that's where I think the conflict can arise. And then, finally, I'd say the concern from the business standpoint is that the presence of a funder may drive up the cost of settlement without a corresponding benefit to the plaintiff. Because if you look at a normal, any case today that may settle for X amount of dollars, the lawyer fee is not going to go down. We know that from experience. The plaintiff's lawyer, if there's somebody else involved in the case, the plaintiff's lawyer isn't going to reduce their contingency fee. They're going to get whatever they always got. And the consumer always has a target of what they need or believe the case is worth. But now when you bring in another person that has their own return on investment in mind, they've got to be paid too. And so I think that dynamic is just going to increase the cost of settling lawsuits, which is, a major concern for the business community.
And here's here's a question I have. I mean, one of the justifications that I've heard for the contingent fee agreement is that the lawyer is bearing the risk financially, right? Is there a universe in which litigation funding removes that financial risk from the lawyer such that there is the ability to work on a reduced contingent fee? I don't know if y'all are seeing that out there, but if that's the logic behind why my fee goes up because there's more risk and more expense, if I have risk shifted that, then is there a universe in which that fee does go down or perhaps stay flat? Have y'all seen that anywhere?
Yeah, it's a great, oh, go ahead, Maya.
I think that the price goes with the risk, right? So when the risk is shifted onto the funder, then the funder is seeking legitimately compensation for the risk that they're taking, just like an insurance company. My anecdotal observation, there's no data on this, but my anecdotal observation is lawyers aren't getting paid less necessarily. But I do think that one thing, I'll say two things about this. One is financing is a service, it costs money. Plaintiffs seek litigation funding when they cannot afford it on their own. That's the only scenario, certainly in the personal injury context. And financing is a utility. It's like electricity. It allows us to do things, all financing, not just litigation funding. And for that, there's a fee to be paid. Where funders can reduce the cost of litigation is it's what economists call agents watching agents. So the funders have an incentive to monitor the lawyers that they're not over lawyering. So at least theoretically, there's an incentive and an opportunity there to enhance efficiency.
I think, you know, Liz, is a very perceptive question because it really goes to looking at where did this industry develop? So, you know, 10, 12 years ago, the litigation funding industry developed in Australia and UK. Why? Because they don't have contingency fees. By and large, they are, you pay your lawyer by the hour. They have a loser pays system. And most consumers couldn't afford to bring lawsuits if they have to pay out of pocket to get legal services. So the litigation funding industry stepped in so that people could bring lawsuits. We don't have that same need in the United States because of the contingency fee system. But I think, you know, so the justification to have the industry here doesn't exist so much in the United States as it did in the countries where it started. And I do think that it can change the dynamics when you have somebody who's involved in the lawsuit as part of their business. Then I think that erodes some of the reasons why in the United States we have a discovery system where the producer tends to pay. You know, why do we have a producer pay system? Because generally we think that an injured consumer doesn't have the money to pay to go after a car company's, you know, to ask a pharmaceutical company for 20 million pages of documents. What consumer has the money to do that? They don't. And so, you know, but now all of a sudden when you realize that the case is being funded by a large institutional investor, that I think whittles away some of the justification we have for our producer pays discovery. I think it whittles away some of the reasons why people have avoided a loser pay system in the United States. Because they say, well, we can't, if the consumer loses, we can't really afford, you know, justify putting the cost of the lawsuit on the injured consumer. But now if we find out the lawsuit is really being funded by a large institutional investor, why not question loser pays in this country like they have abroad? So I think that the more this industry takes hold, it's going to raise lots of other questions about impacts on other parts of our, you know, what have been traditional elements of our civil justice system in America versus Australia or the UK.
So one of the questions that we have from a viewer, and was actually on our topic list, we've talked about the issue of discoverability. Should there be disclosure? What should the parameters of that looked at? Let's shift now to the pros and cons of admissibility. We're at trial, it didn't settle. Should litigation funding be treated kind of like we do stuff under the collateral source rule, and we don't really talk about it? Or are there benefits as well as potential detriments to talking about the fact that a funder has stepped in to fund this lawsuit? And let's go around the room and hear everybody's thoughts on it. Justin, we haven't heard from you for a minute. What do you think?
Sure. So I think there's a pretty distinct difference between discoverability and admissibility, right? It's the reason why discovery is so much broader than the information that's going to come in at trial. I think to the extent that funding has an impact on trial issues. So when we were doing a prep for this, one of the things we talked about is there was some unique funding arrangement where there was a question as to whether witnesses were being paid, right? That's a question that goes directly to credibility of a witness, right? That to me is something, sure, but in a typical situation, it's not relevant, right? It's not relevant to the claims, it's not relevant to the defenses. And so from my standpoint, it's very different than discovery. And the case law, at least to my knowledge, there's not a lot of case law on the admissibility piece. Most of it really has focused on discoverability. And I think that's probably because courts are seeing it similarly. It's just not relevant to what's going on in the case. So that's my 2 cents on it.
I didn't develop mesothelioma because of the presence or absence of a funding agreement.
Right.
I agree with Justin. I think like any issue in a trial court, the admissibility question is going to come down to the relevance and prejudice to the plaintiff if it's admitted. I think, whether somebody receives funding or not probably is not going to be deemed relevant, but there could be information in the funding materials that could be considered relevant. For example, if there are statements by the plaintiff about what did the plaintiff know or when did they know it, that could go to whether the defendant has raised a statute of limitations defense, right? So there could be factual information in that record that goes to claims or defenses in the lawsuit. That material might be deemed relevant. Statements against interest by the plaintiff that may be contained in the materials could be deemed relevant. So I think I'll go to Maya's balancing test to say, generally, I think there's going to be a relevance issue if you're just talking about the financial terms, but to the extent that there are factual statements in the materials that go to the claims or defenses at issue, then you move more into the area where admissibility would be appropriate.
I think we have a consensus on the panel.
Here's a question that Mark's comments raised. Are those types of statements that are being made in the process of obtaining funding generally considered work product? Or how is that amount of disclosure that happens in the process of a funder doing its due diligence perceived in terms of privilege, work product discoverability?
I mean, so from my standpoint, I think the courts are pretty clear. There's sort of 3 lines, right? Courts are generally not protecting information that's strictly covered by the attorney-client privilege, nor should they. That serves a different purpose than the work product privilege, whereas courts are very strong. And if you exchange information with a funder, work product pursuant to an NDA, courts are almost universally allowing that information to remain protected. And then relevance is obviously another line where courts are saying there's no need for discovery on this. What I always tell people is don't tell me things that are just privileged. I don't want information that's just protected by the privilege. I don't need it. I don't want to go near the line. It's not necessary for what I do. And frankly, I don't want to compromise a potential claim. And so we never want information that's strictly privileged. What we tell folks is, for our discussions when we talk to counsel, for example, right? Or when we're talking to claim owners about litigation strategy, that will fall under the work product privilege. That information is generally going to be protected, and courts are pretty clear on that. And if something is just a fact, like the underlying facts, that's not going to be protected regardless of whether or not we have the information or someone else has it. That's discoverable. That's whether or not it's been told to me or not, that's a fact. you can get that discovery regardless. So, my view is, I think the courts have it right. I don't think they should be protecting just privileged information because the underlying policy doesn't make sense. But they have been protecting work product, and I think that, they have it right in the way they're looking at it.
Last thoughts as we approach the top of the hour. Future trends. Where is this industry and where are these issues headed? And Maya, I'll start with you.
I think by far the most important development is what's happening in Arizona and to a lesser degree in Utah, which is either allowing or experimenting respectively with allowing direct ownership of law firms. I think that over time, first of all, more jurisdictions in the United States will adopt this model, I'm sure. And this will partially replace litigation funding. So what we're seeing now will become sort of an obsolete, clunky way of doing things, because to a large extent, it developed, especially the portfolios, as a way to work around the fact that funders can't just invest directly in a law firm, so they invest in the portfolio that a contingency firm basically owns or is its main economic value. So I think for people who are interested in that, that's the thing I would watch most.
Mark, future trends.
I think that's great that Maya mentioned that, because I agree. I mean, I think, we talked at the beginning of the hour. I think one trend we're going to see is this industry is going to continue to grow, maybe even more quickly if the economy sort of struggles for the next couple of years. And Maya really hit on an extremely important point, that I think the focus will be more about non-lawyer ownership of law firms. Arizona and Utah sort of chipped away a bit at this. The Florida Supreme Court just like a month, like 2 months ago, said, no, we're not going to go down that road. And they said no after unanimous decision by the Florida bar. So, the interest, it seems, of plaintiff and defendants were aligned on that. But some of this question about disclosure would seem to go away if the outside funders are able to buy into the law firms directly. Then there's nothing to disclose. They're part of the law firm and they're funding the lawsuits at that time. They're not a third party anymore. So I think that it will change the practice of law. It would certainly go to the heart of whether we even have this disclosure debate if the industry moves in that direction.
Justin, future trends.
Yeah, I think what Maya and Mark said is right. I do expect to see more of the attorney ownership. I think it will be slower than people, a lot of people want or don't want, but I think it's going to happen in, kind of small steps, but it's coming. I think we are going to see more and more rules requiring disclosure, like Judge Connolly's order, for example, which was a couple of weeks ago. Now, I do think we're going to see more of that. I think different courts are going to take different approaches in terms of what they're requiring from a disclosure standpoint. And I think as that continues to happen, the body of law, which is already relatively robust, will continue to grow. And but I do think we're going to be seeing more and more on the disclosure piece and more required disclosure as we go forward.
Well, good news. In an upcoming webinar, we'll have a panel talking about the pros and cons of non-attorney ownership and control of law firms. So stay tuned. Gosh, guys, what a great conversation. Loved having the different viewpoints, loved all the perspectives that you brought. For those of you watching, we've put the course number for CLE credit in the chat. And thank you so much for joining us. If this has whetted your interest in what is going on in the world of litigation management, by all means, go to our webpage and take a look at what the full course descriptions and curriculum looks like in our LLM and litigation management. Hopefully, we'll see you next month. Thank you and have a great day.